I am asking Congress to pass legislation to prohibit the late-term abortion of children who can feel pain in a mother's womb.
Who are we to set in judgment of these women making a decision between them and their physician and their God above?
Thank God in November we sent more pro-life senators to the United States Senate. We have delivered the strongest pro-life results in history.
I have lost 7 pregnancies in varying points of time before 20 weeks and 1 after 5 months. Her name was Juliet. But no matter my faith, my beliefs, my losses, I have never ever strayed from the basic principle that each woman must be able to make her decisions in consultation with her God and her family.
The debate over abortion in America continues to divide the country.
Abortion on demand and without apology!
And 45 years after Roe v. Wade ensured women's right to choose, many states are restricting access to the procedure. Since January, over 300 anti-abortion bills have been introduced in states across the country. The number of bills introduced that would ban abortion after 6 weeks, known as fetal heartbeat bans, are up 63% compared to last year. As anti-abortion legislation sweeps across the country, Yahoo News travels to Louisiana to explore the story behind its anti-abortion law, Act 620, likely to be the first abortion case heard by the new conservative-leaning Supreme Court.
People have heard of Roe v. Wade. In this country, there is a constitutional right to choose abortion, but the reality is, throughout the country, anti-choice forces have figured out how to overregulate abortion and extinguish abortion access even while leaving Roe v. Wade on the books. This is a very well-calculated strategy pursued over decades, and we're now up to over 400 laws throughout the country. Anti-abortion forces have been using trap laws to put abortion providers out of business. TRAP stands for Targeted Regulation of Abortion Providers. If women can't actually get an abortion, then for all practical purposes, abortion is banned. We have numerous states throughout the country that are down to only 1 clinic, handfuls of doctors, and huge swaths of the country that are essentially an abortion desert, where women cannot access care at all. Louisiana's law is called Act 620. And what it requires is that doctors who perform abortions have admitting privileges at a hospital within 30 miles of where they practice. Admitting privileges at hospitals is something that might sound good on paper, but it's totally not necessary. Women can access a hospital even if their doctor doesn't have admitting privileges. Doctors have transfer agreements that ensure that a woman gets all the care they need without admitting privileges. Hospitals give admitting privileges to doctors who send them lots of patients. It's a business relationship. Abortion providers don't send patients to hospitals because the procedure is so safe. So a legal requirement that they have admitting privileges is a classic catch-22. Doctors can't get them, hospitals won't grant them, and so it effectively puts the doctors out of business. Supporters of laws like Act 620 say this is all about women's health, and that's just a lie. These laws are about shutting down clinics.
I am a pro-life supporter because of my faith. That's first and foremost. I respect life. I believe that life begins in the womb. I'm pro-life at all stages of life, from the womb to the tomb. When I ran for office, I told everyone that I'm gonna, pray. I'm gonna hear from God. I'm gonna let my Christian values direct me. Although the president and I disagree on a number of issues, trust me, I do support his stance on abortion. Act 620 came about because years ago, the legislature put in place an ambulatory surgical center law. What it said was that regardless of the surgery that was being performed, that a physician had to have admitting privileges within a 30-mile radius of a hospital. Most of us just blindly thought it included abortion facilities. What we're saying is that for this surgical procedure alone, we're relaxing Louisiana's healthcare standards.
We've been testifying against anti-choice bills since 2014 when the admitting privileges bill was introduced by Representative Katrina Jackson. The Louisiana admitting privileges law and many of the other TRAP laws are medically unnecessary and yet often passed under the guise of women's health and safety, which I find to be very disingenuous of legislators. I think that what's really important for folks to know is that 1 in 4 U.S. women have an abortion by the time she's 45. I've had 2 abortions, which is something that's not much talked about for obvious reasons. I remember that day pretty vividly. I was really struck by the laws and restrictions that were in place in Louisiana and the impact it had on the women that day. Coming up with money to pay for it because of the restrictions on insurance coverage. Folks were worried about getting back home to meet their kids at the bus stop or at their school. When I left the clinic that day in 2011, I just remember thinking someone should do something. I reached out to friends and asked about possibly starting an abortion fund here in New Orleans. Part of the work that we do is talking about abortion access unapologetically and giving folks an opportunity to have that discussion. We provide financial assistance to people seeking abortion care. Many of the women that we're serving are employed or students. They're mothers, and 82% identify as being religious or spiritual. My name is Amy Irvin, also a founding board member of the New Orleans Abortion Fund. I urge you to oppose this bill and put women's health care before ideology. I've testified on many bills in front of many of the same legislators, and I don't think that they really appreciate both the need for abortion as health care, but also the impact these restrictions have on specific communities. We know that restrictions like these impact marginalized communities, women of color, immigrant women, youth the most. Women of privilege will always be able to access this care. That isn't going to be the case for the vast majority of people here in Louisiana.
In 2014, Act 620 passed. That was a big year for me. And then after that, it was an immediate challenge before it went into effect. And abortion providers filed suit because they said that it was going to place an undue burden on the right of women to have abortion and their access to abortion.
Act 620 was scheduled to go into effect in February. We went to the Supreme Court and said, on an emergency basis, you have to block this law. If you don't, all the clinics in the state are going to close except one. And to the surprise of some, the Supreme Court agreed. But the ruling is only temporary. The court still has to decide whether they're going to take this case and strike down the law. All we're asking the Supreme Court to do in this case is uphold its own precedent. In 2016, the Supreme Court said this same law in Texas is unconstitutional. It can't somehow be constitutional one state over in Louisiana.
I took an oath to legislate within the realms of the Constitution and the laws of the land. So Roe versus Wade is the law of the land. I don't like it. Hopefully one day it'll be overturned. But the bottom line is, it doesn't restrict us from legislating in the area of women's health.
Our experiences have been silenced as a result of the shame and stigma that people often experience after having an abortion. I find that it's really important to have those conversations, and I know in telling my own story, people have come up to me afterwards and said, thank you for sharing your story. It's given me courage to tell mine.
It can be uncomfortable to talk about, but it's a necessary conversation so that people realize that there is no typical reason why women have abortion. There's lots of reasons, and those reasons matter for women, and we should trust them to make those decisions for themselves.